My lord, I have mentioned.
Yes. You are making a mention for division bench or single bench?
My lord, I have a mention for item for unlisting of a matter today.
Is it division bench or single bench?
Single bench, my lord.
So we are in a division bench. Why are you making a mention for division bench
My lord.
before a division bench? You come back second half or whenever the bench
Okay.
rises. Yes.
Your Lordship, may I seek indulgence in mentioning hearing item number 11.
11.
Yes, Your Lordship.
Yes.
This case is taken by my senior, Miss Mary. Due to some personal difficulties, she cannot came today. So if this matter be taken after a week or after a week.
Okay. On the request made on behalf of
Miss Mary.
appellant or respondent?
Respondent.
No. Respondent.
Additional public prosecutor.
Matter stands deferred to be listed after 1 week. Who's for the petitioner?
I'm for the petitioner.
Any
Lordship.
objection?
No objection, Lordship.
Right. Mr. So-and-so appears for the, you are Mr. Tochang.
Taucho, amicus.
As the amicus appears for the petitioner, relist this matter after 1 week.
My Lord's presence of my Lord's legal aid counsel, I'm representing R2 informed.
Mr. Jordan appears for respondent number 2 as a legal aid counsel.
My Lord, make I mention with the consent of the other party with regard to item number 10 of hearing list. My
10.
Lord, if this matter may be come up again on 21st of September.
21st of
My
September.
Lord.
Yes, my Lord.
Yes.
My lords, I appear through VC.
Oh,
My lord, I appear for the appellant in this matter.
all right.
So, my lord, even if the matter comes up on 21st 9/2026, since they have informed me before, my lord, so we have no objection as such today. But, my lord, my humble prayer is this, my lord, that let this be the last occasion for adjournment, because on the last occasion also, my lord, we had done a comprehensive hearing. I mean, we had done a hearing for quite a long time, my lord. And after that, they had asked for time for
Is this
adjournment.
matter part heard before any other bench?
It's not part hard, my lord, but then we had invested quite a considerable amount of time, my lord, hearing this matter also.
Then why
And then after that, they had asked
why
for
are you
time.
agreeing for an adjournment?
My lord, I
You are
am
agreeing
ready.
for an adjournment?
My lord, we are ready. The other side wants an adjournment.
All right. Respondents, on the prayer of the respondent, matter stands deferred to be listed on, when do you want it? 21st?
My lord, they
21st.
wanted 21st, but my lord, let this be the last occasion for
No, I think it
adjournment, my
should
lord.
be 23rd, which is a Wednesday. That's when the
Certainly, my
DVs
lord,
are there. 23rd of September is agreed to by the council for the parties. You are Mr. Joseph?
Yes, my lord.
Mr. Joseph appears for the writ petitioner. Yes.
And my lord, let my objection, let that submission be
No,
reflected, my lord, that
we have not recorded that you have agreed. We are only recording your presence.
certainly, my lord.
Oblige.
For admission, item number 1.
Yes.
Yes, Lordship, as per order dated 22/7, we have served a copy to respondent number 8, 9, 11, 12, 13, and 15 by way of Dusty on 30/7/2026.
Respondent 14,
8, 9, 11, 12, 13, and 15.
15.
These are the contractors for different jails.
Who's appearing for 14?
I appear, my lords. My lords, we're seeking some more time. In fact, my lords, as per the government data, my lords, our work progress was 50% in the last hearing. That was in May. So, my lords, it's considerably risen. We want we'll give the updated, my lords, progress on our works, my lords.
Okay, you are appearing on behalf of?
Wabzo, my lords, respondent.
You are the contractor.
Yes, my lords, for Serchi district.
All right.
My lords, I'm appearing for respondent number 8. We have filed our power last week, so we seek time for filing our affidavit for the respondent number 8.
8.
AIE Construction,
Okay.
Aizawl District.
And my lord, I'm appearing for respondent number 9, the Huawei Constructions in the Lumley district.
You have filed your
I have
counter?
filed my power, my lord. And I'm seeking to file my affidavit, my lord.
You have not filed your counter affidavit.
I have not filed, my lord.
Counsel appearing for respondents 8, 9 and 14. Pray for further time to complete their instructions and file necessary affidavit. Who's for the petitioner?
I'm for the petitioner, Lordship.
Ms. Rosaline
Yes, Lordship.
appears for the writ petitioner. As per the earlier order, the steps on respondents number 8, 9, 11, 12, 13 and 15 were undertaken. By Dusty,
Yes, Lordship.
an affidavit has also been filed. Are the respondents represented? 8, 9, 11, 12, 13 and 15?
Today, 8, 9, and 14 have represented, Lordship. The rest are still absent.
11, 12, 13 and 15 are not present, is it?
Not yet represented, Lordship.
Right. Council, respondents 8 and 9 are represented, whereas respondents 11, 12, 13 and 15 are yet to be represented by the council. Considering the prayers made by the respondent, release this matter again after 2 weeks. We are giving you 2 weeks to file your counter. Release this matter again on 9th of September.
Obliged, Lordship.
Item number 2.
May it please, my lords. My lords, in compliance of the order dated 5/8/2026, we have filed the additional affidavit accordingly, my lord. However, my lord, there's been a development, my lord.
Yes.
And recently there was a meeting held in the office of the Chief Secretary on 12/8/2026, my lord. If my lords will allow me to produce a copy of the meeting minutes, my lord.
You have filed affidavit, you have not enclosed it.
No, my lord, this is
Subsequent to that.
subsequent. Yes, my lord.
Okay, what is that? What is the decision?
At point number 6, my lord, the second page, towards the bottom, my lord.
Yes.
They have approved for the proposal for exchange of the land, my lord.
Who are we? This is the meeting of state level government land authority.
Yes, my lord. Under the chairmanship of the Chief Secretary, ma'am.
All right. So you have approved that.
Yes, ma'am.
When is the actual handing over taking place?
My lord, as per point number 6, subject to the condition that a memorandum of exchange shall be executed by both departments, including the formal handing over of the existing building standing on the respective lands, my lord.
This is presently under which department? The land which is sought to be handed over to the
Printing and stationery, ma'am. Printing and stationery.
printing and stationery. So who represents that department?
The Commissioner Secretary, ma'am.
Any council? Government council?
They were implemented, my lord. I'll be representing them, my lord.
You are representing.
Yes, my lord. All the state respondents.
All right. So you draw up the necessary memorandums, whatever is there, you and exchange it.
Yes, my lord.
As per the last order, there was some demand for some compensation. Are you still pursuing that?
No, my lord. Out here, it's already made. They have made it clear in this meeting, my lord.
All right. Yes, Mr. Malhotra.
This,
You have a copy of this?
yes, I've just received it. This may also be brought on record by way of an affidavit.
Yes. The Mr. Malhotra appears as you are the amicus.
I'm the standing counsel for the Aizol bench, Gauhati High Court Aizol bench.
Appears on behalf of the Gauhati High Court Aizol bench. And Mr.
Samuel, ma'am.
Samuel, you are the additional AG
Yes, my lord.
appearing for the state. Learned additional AG submits that pursuant to the earlier orders passed by the court, an affidavit, additional affidavit has been filed as directed. He further submits that on 12/8/2026, there was a meeting of the state level government land authority held, wherein the chief secretary is the chairman of the committee. And at point number 6 of the said minutes, the following was recorded. You extract number 6. He therefore submits that now the concerned departments are required to execute the memorandum of exchange, including the formal handing over of the existing building standing on the respective land, and thereafter the exchange would be complete. In terms of the minutes, or in terms of the decision arrived at in the state level government land authority. Stop. A copy of these minutes is placed before the court. Considering the gravity of the issues, we permit learned additional AG to bring these minutes on record by way of an additional affidavit, so that all counsel representing the respective parties have will have copies thereof. Stop. Meanwhile, as agreed to in the state level government land authority, agreed to upon by the state level government land authority in its meeting held on 12/8/26, let the concerned departments formally execute the memorandum of exchange, including the formal handing over of the existing buildings, within a period of 4 weeks from today. Let this matter therefore be listed. We'll make it 3 weeks.
Yeah.
3 weeks from today. Let this matter be listed again on
Your Worship, if possible, 9th of September.
3 weeks will not be over. 16th, we can have it on 16th. Or is it possible to have it on 11th or something? We can have a special bench. 11th?
11th?
16, my lord, they'll need time to finalize. Last day.
All right, we give you 2 weeks. Let us have it on 9th. You make an attempt to sort it out. The matter be listed on 9th of September.
I'm
By-
obliged.
By which date the minute shall be brought on record by proper pleadings as permitted, and also the learned additional AG will apprise the court with regard to the execution of the memorandum of exchange between the parties.
I'm obliged.
Relist accordingly.
Item number 3.
Yes.
Your Lordship, my senior Miss Mary cannot attend the court due to personal difficulties, although it has been fixed for today.
This has come for the first time.
No, Your Lordship, it has been fixed for admission hearing today. So, can this matter be
We
taken?
don't find the orders. Orders are there. The order doesn't. Was it? It's come for the first time. Is it? It's come for the first time, right?
No, Your Lordship.
By which order?
By which order dated 12/8/2026, the IA was condoned.
No, delay condoned is okay,
Yes,
but
Your
the
Lordship.
appeal is come up for the first
Yes,
time.
Your Lordship.
So we'll issue notice here. Heard counsel for the parties. There's an appeal directed against the judgment and order dated 6/5/2024, passed in WPC.
Except 12/2/21.
Huh?
Index of 12/2/21 million.
The order was 6/5/24. Certificate copy. Page number 7, Roman 7. 6/5/2024, passed in WPC 64 of 2023. And WPC 52 of 2022. So we should notice MS
Cedar Raphael on behalf of Victoria Ralte.
appearing for the
Respondent.
appears for the respondents. Which respondents?
All the respondent.
All the respondents.
Lordship, can I make one request? My senior is on leave, so may this matter be passed over for a
We are
time
only
being.
issuing notice.
Lordship, on the last court order dated 12/8/26, we have already served the copy to the respondents.
Sorry?
We have served the copy to the
That's all right.
respondent and
MS so appears for the respondents, writ petitioners. You are the writ petitioners.
no,
Yes, Your Lordship.
Therefore, no formal notice need be issued. However, extra copies, if not already served, be served within a period of 1 week from today. Call for the records of the connecting of the writ petitions in which the present appeal is filed. Matter therefore be listed after the returnable date. We are only issuing notice. This has come for the first time.
My lord, can we have it on the next week? There's contempt pending in this case, connecting this case.
No, but you still have to issue notice. It's come
Yes,
for the
yes.
first time.
Yes, I can accept notice, my lord. I have already appeared in the IA. There was an IA for condonation of delay.
Right,
That
but
was
the
recently
appeal,
disposed
is
of.
there any other appeal? Is there any order passed in the appeal earlier?
Not yet.
So this is the first time.
Yes, my lord.
So we have issued notice. We made it returnable after 4 weeks. We can make it, 2 weeks for you?
Can we have it on next week, my lord?
Why?
Because of the pendency of the contempt.
Maybe, but you'll have to do something in the appeal.
I have already received.
We can't dismiss the appeal without issuing a notice, assuming you want that.
No problem. If that is the case, my lord, I would like to raise one objection in the memo of appeal which I have recently received. In the writ petition, my lord, I'm the writ petitioner. The said respondents have filed their counter affidavit, and I have also filed my reply affidavit. But in the present memo of appeal, they have omitted to enclose the reply affidavit filed by the petitioners.
You raise it, we'll record it,
Yes, my lord.
and they will have to rectify it. You can file your objections if you want. We have issued notice in the matter, and whatever objections you want to raise, you raise it by the next date. And thereafter we'll admit it if required, or we hear the matter, or we finish off the matter at the admission stage.
All right, my lord.
All right. Yes. So returnable after 3 weeks. 16th September.
Much obliged.
Item number 4.
My lord, as per the last order, I am supposed to file the status report with regard to shifting of the district jails. But, my lord, in that regard, we have no updates to give because, my lord, we are still asking for a fund from the Planning and Program Implementation Department under the 16th Finance Commission, which is still awaited, my lord.
What status report are you supposed to furnish?
My lord, with regard to the, we have, my lord, in the last occasion, we have filed our affidavit. Affidavit dated 16/6/2025.
16/6/26, yes.
Yes, my lord. Here we have given our response, my lord, at page 3,
Page 3,
subpara C.
shifting of the district
Yes.
jail to new
To a
location.
new location, and the proposal for construction of the same with a project cost amounting to so and so has been submitted to Planning and Program Implementation Department for financing under the 16th Finance Commission.
When are you likely to get this approved
My
or
lord,
sanctioned?
we are still awaiting for that, my lord. We cannot exactly say the date, my lord, so.
No,
if I'm making-
you are the additional AG.
Yes, my lord.
So you get your instructions from this
From
Planning
the
and Program
planning, yes, madam.
Implementation Department to find out what have they done with the proposal.
All right, my lord.
How much time do you require?
My lord, 3 weeks' time?
Supreme Court has set a time for filing of the status report, 21st.
21st of, is it? By which
Worship,
order?
if
Order dated 17, it is reflected there, 17/6/26, second page. The committee so constituted has to furnish the status report before this court on 21/8.
Second page of the affidavit.
No, order.
Which order? Date?
17/6/26.
Oh, that he print out on Martin.
Where is the order of the Supreme Court? 26-2?
Your Worship, it is in the, it's a suo motu PI, Your Worship.
Yes. Is the order available here?
Yes, Your Worship, it is annexed to the letter, you have the letter written by the Registrar General to the Register Judicial, to the Registrar, from the Supreme, from the Registrar Judicial to the Registrar Aizol Bench. It is dated 20th of March 2026.
Okay.
The Supreme Court judgment has been annexed to that.
Yes. Where is the specific direction?
At page 129. Your Worship, I'll take your Lordship to page 105, the operative directions.
135.
105
105.
of the judgment of the Supreme Court.
Yes.
Under the subclause A, underutilization of existing OCI facilities and absence of OCIs in several states and union territories, subclause 1. The states of Arunachal Pradesh, Chhattisgarh, Goa, Haryana, Jharkhand, Manipur, Mizoram, Nagaland, Sikkim, and Telangana, which presently do not have any functioning OCIs, shall, as a first step, undertake an assessment of the feasibility and necessity for establishing OCIs within their respective jurisdictions. Upon such assessment, the said states shall develop a protocol for establishment of OCIs and or open and semi-open barracks. So, Your Worship, this was the direction. Now, if I may take your Lordship to page 129.
Yes.
Subclause F, compliance and monitoring. It's evident that directions issued by this court in by this court by order dated 8th of May 2018 in re inhuman conditions in 1382 prisons have not thus far yielded any meaningful or positive results. In order to ensure that the present judgment does not suffer the same fate, it is imperative to exhort the High Courts to assume an active role in overseeing and ensuring effective implementation of the directions issued herein. With the aforesaid objective in view, we proceed to issue the following directions. For ongoing compliance and monitoring, all the High Courts are directed to register a suo motu writ petition as a continuing mandamus for the purpose of monitoring compliance with the present judgment within the respective jurisdictions, particularly with respect to the establishment, functioning, and expansion of OCIs. Number two, to facilitate effective implementation at the executive level, every state and unitary shall constitute a monitoring committee for the management of OCIs to be headed by the executive chairman of the State Legal Service Authority or his nominee, including a former judge of the High Court, with the following members. Members are given their urgent. Subclause 3. Where the chairperson of the monitoring committee is a nominee of the executive chairman of the State Legal Service Authority, such nominee shall be entitled to appropriate remuneration. I'll take your lordship to page
133, I think. That's where the date.
132, subclause 6.
Yes, that's where the date is.
Yes, Your Honor. The state committee shall submit status report to the concerned High Court on regular quarterly intervals, detailing steps taken towards compliance with directions issued herein, the utilization and expansion of OCIs, and any difficulties encountered in implementation of the directions issued by this court. The first such status report shall be placed on record before the concerned High Court on or before 21st August. So, Your Worship, this status report is to be submitted by the monitoring committee. The monitoring committee has been constituted by the respondents by annexure 1 of the affidavit filed on 16th of June at page 5, Your Worship. This is the notification dated 18th of May 2026. Has Your Lordship got?
Yes.
In the interest of public service, a state monitoring committee for overseeing and monitoring the establishment and authorization of open correctional institute in the state is hereby constituted with the following composition. So, this committee has to submit the status report.
Yes,
So I think, Your Honor, this committee may be pleaded as a respondent. Till date, the committee has not been pleaded. I think unless they are pleaded.
Is it necessary to implement them? They are required to comply with the court's order.
Yes, madam.
That's all.
No, madam.
Supreme Court has clearly directed that first status report shall be filed by 21st. So the committee will have to file it.
Yes, madam. A state monitoring committee has already been set up. And my lord, I have received instructions that a meeting will be convened at the earliest because the executive chairman is on official tour at the moment. As soon as he returns, my lord, a meeting will be convened at the earliest.
So let the committee, you are the additional AG, you can communicate the order
Yes, my lord.
and ask them to file it.
Yes, my lord. I'll do that.
Is there any specific order for issuance of notice to the parties? State of Mizoram?
In the first order, my lord,
13th of May. No.
All right, we will implement this committee also as a party respondent,
Yes, I have nothing.
so that Regular updates are available.
Yes.
Yes. Huh? We immediately committee. No? Then we give them to file the report on 31st. Will have to. Hmm? This oh, okay.
I think Your Worship, because it is the committee which has to submit the status report.
All right, who's the executive chairman? Who's the executive chairman of this Mizoram state?
Mizoram State Legal Services Authority.
Vincent.
Vincent, chairperson.
State Legal Service Authority.
Executive chairman.
All right, for the time being, we will direct, we'll reiterate the directions of the Supreme Court for filing the report by 21st. This writ petition, suo motu,
Justice Nelson.
has been registered in terms of the directions issued by the Apex Court in WPC numbers 1082 of 2020 within bracket Suhas Chakma versus Union of India and others. Stop. The Apex Court while issuing the directions, operative directions, had held that some of the states, including the state of Mizoram, did not have a functioning OCI. What is the full form?
Open Correctional Institutions.
Open Correctional Institutions. Does not have a functioning OCI. And therefore, as a first step, those states were directed to undertake an assessment of the feasibility and necessity for establishing the OCI within their respective jurisdiction. Upon such assessment, the states will develop a protocol for establishment of OCIs and obligor for open and semi-open barracks. So, the Supreme Court further directed that a monitoring committee be constituted under direction F, who shall oversee, facilitate, ensure the faithful, effective and timely implementation of the protocols so framed by the states and the union territories. Stop. The further directions of the Supreme Court. For compliance and monitoring of the same, this order laid down the following further directions. Page number 129, Roman 1 onwards. Para. At clause 4 of the directions, the Supreme Court at clause 3 of the in terms of the said directions, for effective implementation at the executive level, every state or union territory is required to constitute a monitoring committee for management of the OCIs, to be headed by the executive chairman of the State Legal Services Authority or his nominee, with the members which are mentioned in clause 2, which are reproduced above. Stop. The State Committee, the State Monitoring Committee is responsible for ensuring compliance of the directions issued by the court, overseeing the utilization, functioning and expansion of the OCIs, facilitating timely identification, transfer of eligible persons from closed prisons to OCIs, and periodically reviewing the progress and addressing systemic impediments in the implementation of the directions issued. The committees were directed, each state and union territory was directed to constitute the monitoring committee within a period of 4 weeks from the date of the judgment. And the state committees are to submit status reports to the concerned high courts on regular quarterly intervals. And the first such status report was directed to be placed on or before the concerned high court before the concerned High Court on or before 21st of August 2026. Para. In deference to the orders passed by the Apex Court, the State of Mizoram, by notification dated 18th May 2026, had constituted the State Monitoring Committee for overseeing and monitoring establishment and operationalization of the open correctional institution within bracket OCI in the state. Stop. The committee, the chairman of the committee is the executive chairman, Mizoram State Legal Services Authority. Number 2, additional secretary of Home Department and Inspector General Prisons are the members of the state committee. Stop. Para. In terms of the affidavit, which was filed by the state respondents on 16th of June 2026, it is stated that a proposal for construction, this is construction of what? OCI.
OCI, my lord, yes.
Construction of the OCI amounts to 20.
This is for, my lord, shifting of the jails, my lord.
The district jail will be shifted to a new location, and the existing district jail will be utilized as a OCI.
The proposal for construction of a new jail necessary for shifting the existing ISOL jail premises to a new location amounts to rupees 207777,000. And it has been submitted to the Planning and Program Implementation Department for financing under the 16th Finance Commission. Stop. Once the construction is completed in the new premises and the existing district jail is shifted to the new location, the existing premises of the district jail will be utilized for establishment of the OCI. Stop. Para learned additional AG appearing for the state, MS Linda, submits that her instructions are awaited with regard to the status of the proposal which is submitted to the Planning and Program Implementation Department for release of the finance for construction of the new jail premises. Stop. Para. Be that as it may, since the monitoring committee has already been constituted by the state of Mizoram by the notification dated 18th of May 2026, and since there is a specific direction by the Apex Court at direction F, heading compliance and monitoring, Roman 6, that the first status report to be submitted by the monitoring committee before the High Court shall be on or before 21st of August 2026. We permit the State Monitoring Committee to take necessary steps for submitting its report in terms of the directions issued by the Apex Court at clause number so-and-so, and place the report before this court on or before 21st of August 2026. Stop. Considering the specific directions issued, let a copy of this order be marked to the, do you have a registrar, registrar judicial here? To the registrar, concerned registrar of this High Court for immediate onward communication to the monitoring committee for due compliance of the directions of the court's order. Let this order be communicated by way of a special messenger and email to the monitoring committee. Let the matter be listed before the next available bench immediately.
All right.
Nobody has been designated as the secretary or convener. Whatever. Proceeding in the complaint.
That is for the committee to do.
Item number 5.
Lordship,
Yes.
Here I appear through the VC, man.
Yes.
If I may kindly be granted 1 week's time for filing my objection to the application, the criminal appeal, man. Actually, this is a bail application.
You have filed?
No, I am to file only, man.
Okay. How much time do you want?
1 week's time, my lord.
1 week's time. Mr. Lalven Zanga.
No, my lord.
Ah.
C.
Oh, sorry. C. Zoram Chana. Special PP.
My lord.
NIA. Submits that he be permitted further week's time to file the objections to the bail application filed. Considering the charges leveled against the petitioner and the provisions of the statute, the court permits the learned special PPNIA to file their objections within 1 week. Mr. So-and-so appears for the appellant. Matter be listed after 1 week, by which time the objections be filed.
Obliged.
It's a bail application. In a bail.
Item number 6.
May it please Your Worship, this is the first time the matter has been listed. This is a writ appeal against the judgment and order dated 31st of July 2026 in writ petition number 123 of 2025. The main grievance of the appellants against the dismissal of the writ petition is that they had challenged the action of the state respondents in cancelling the selection process as well as the appointment orders to the post of sericulture demonstrator. Yeah. Initially, the state respondents had issued the advertisement, then the examination was conducted. After that, the interview was conducted. After that, the results were declared, and even the writ appellants petitioners were appointed to the post of sericulture demonstrator. But subsequently, 4 months down the line, their appointment orders have been cancelled because of a complaint submitted by a student organization that there were some discrepancies in the examination. On the basis of the complaint submitted by the student organization, the respondents had constituted an inquiry committee, and the inquiry committee had given its report. And if I may take your lordship to the findings of the inquiry committee, which is at page 108. If I may read your
Yes.
page, clause number Roman 5, findings. Inquiry committee, after thorough investigation within available information and sources, concluded the investigation with the following fact and findings. Number 1, the inquiry revealed that 3 candidates, Angela Lalrin Moy, roll number 2, Walal Sung, roll number 34, Lalram Sang, roll number 12, confessed that they carried mobile phone inside the examination hall in the first day of examination, which was not permitted and violates instructions to the candidates, point E, in the admit card issued to the candidates. It appears that the official, not attempting effectively to prevent the candidates from carrying mobile phone inside the examination hall, even though one candidate, Wangal Nienga, roll number 37, stood up and verbally complained and requested to conduct physical checking. This is a serious lapse and error committed by the conducting officials, which is violation of para 26 of the Mizoram Direct Recruit Conduct of Examination Guidelines 2018. Number 2, one candidate, Wanal Nienga, submitted a written complaint to inquire into conduct of paper 1 examination to the director on 11th of April 2025. The matter was not brought to the notice of the administrative department, which appears to be a serious lapse in the part of the directorate, as withdrawal of the case by complainant neither influenced nor satisfied other candidates. Further, it's flare up suspicious and resort to submit of complaint to the MZP, that is the student organization, and eventually to the department. Recommendations. Number 1, examination of paper 1 and 2 may be conducted afresh to ensure free and fair competition under a close vigil of the administrative department in order to avoid complaint in future. The investigation revealed no irregularities established in paper 3 in personal interview. Number 2, officials detailed and directly involved in the examination hall of the above recruitment examination may not be deployed again to maintain virtuous examination atmosphere. So these were the recommendations of the inquiry committee. Thereafter, on the basis of that, Your Worship, the respondents had taken the opinion of the law department, which is at page 110.
Yes.
And after that, at page 111, by this notification dated 29th August 2025, the state respondents had cancelled the selection process and had ordered for fresh conduct of the recruitment process, and the appointment orders of the petitioners, writ appellants, was also cancelled.
No. After this decision taken by the committee,
Yes.
page 108,
Yes.
the findings were to hold the 2 papers
Yes.
afresh.
But in spite of this, Your Worship, the decision of the department was to cancel the whole selection process, which is at page 111, last paragraph, and to conduct the selection process afresh.
Right.
as well as to cancel the appointment orders of the writ appellants.
Okay, that is on the advice of the law department.
Yes. Advice of the law department was, Your Worship, the
No, that's what it
department,
says.
yes. But the advice is at page 110, Your Worship. If I may read, Your Worship.
Yes, yes.
The matter regarding reconduction of the examination potentially leading to cancellation of the sericulture demonstrator's appointment order under sericulture department has been examined in the law and judicial department and is hereby returned with an advice to carefully consider the findings of the inquiry committee in light of the 4 key principles laid down by the Honorable Supreme Court in state of West Bengal versus Baisakhi Bhattacharya, bracket Chatterjee, and others dated 30th of April 2025, which are as follows. Number 1, entire selection process can be set aside if systemic fraud is established. Number 2, proof of irregularities need not meet the criminal standard of beyond reasonable proof. Number 3, purity of process must be given precedence over inconvenience to unaffected candidates. Individual hearing may not be required if the entire process is vitiated.
Right.
So, on the basis of the opinion of the Law and Judicial Department, the Sericulture Department had decided to cancel the entire selection process and to conduct it afresh, as well as cancel the appointment orders of the petitioners.
Okay.
And at page 112, and this is the office order cancelling the appointment order of the petitioners. After a period of 4 months, they were appointed in May, and the cancellation order came up on 3rd of September. Your Worship, in this regard, there are several judgments of the Supreme Court as well as the High Court also, where the tainted can be segregated from the untainted, then the entire selection process needs not be cancelled. Recently, Your Worship, the coordinate bench of our Honorable High Court has also considered this point. If I may refer to this judgment, Your Worship.
Yes.
This is 2026 SCC Online Gauhati 4627, Ranjit Kumar and others versus Union of India and others. This was regard to the decision of the respondents to cancel the selection process for appointment to the post of Chief Law Assistant under the Railways Department. If I may take your Lordship,
Yes.
to para 17, para 16. Your Lordship.
Yes.
I'll read from para 16. What needs to be emphasized here is that only in extraordinary fact situations where the examination in question is vitiated, the entire examination process ought to be cancelled. In Vanshika Yadav versus Union of India, 2024 9 SCC 743, the position of law in that regard was again clearly adumbrated. A 3-judges bench of the Supreme Court in this case has opined that it is a settled law that cancellation of an examination, either for the purpose of gaining admission to any professional or other courses, or for the purpose of recruitment to government posts, is justified only in cases where the sanctity of the examination is found to be compromised at a systemic level. A court can direct cancellation of an examination or approve such cancellation by the competent authority only if it is not possible to separate the tainted candidates from the untainted ones. In the case at hand, the written examination was held and the results were declared. However, the results had to be re-evaluated as one of the candidates had objected that the answer keys were not published before the declaration of the result. This has led to re-evaluation. The defect has completely been remedied. The admitted case of the respondents is that there was some suspicion with respect of the 2 of the candidates. Those 2 candidates, the petitioners have argued, and rightly so, could easily have been segregated from the rest of the candidates, and the examination process should have been taken to a logical final conclusion. If we examine the decision of the authorities of cancelling the entire long-drawn process of examination, it does not pass the muster of Wednesbury's principles of proportionality tests. The decision of the respondents and of the tribunal does not appear to be fair, reasonable, and well-balanced or harmonious. For the aforesaid noted reasons, we, while disagreeing with the opinion of the tribunal, set aside the impugned judgment dated 8th of December 2025, passed in original application number so and so, and direct the respondents to complete the process of examination after segregating the case of the two candidates and take the process to a logical conclusion within a reasonable period of time, preferably within a period of 3 months. So, Your Worship, in this case also, the inquiry committee has submitted its report where they have come to a specific finding that 3 candidates had taken their mobile phones into the examination.
These are not the appellants.
These are not the appellants. So it is a case where the tainted can be segregated from the untainted. So my humble submission, Your Worship, is that the decision to cancel the entire selection process as well as to cancel the appointments of the petitioners is arbitrary, since the tainted could be segregated from the untainted.
What is the status of the appellants in terms of their service?
Your Worship, they were appointed, they worked for 4 months.
Then terminated.
And then terminated. As on date, no fresh selection process has been initiated by the state respondents. And the Supreme Court has also held that unless there's systemic fraud in the entire process, and if the tainted can be untainted, the tainted can be segregated from the untainted, then the question of cancellation of the whole selection process does not arise. The inquiry report in the present case is very clear that only 3 candidates had taken their mobile phone into the examination hall. So they could have been punished, Your Worship. While then the
how many appellants are there?
Your Worship, there were 4 writ petitioners. There are only 3 writ appellants now.
3 writ appellants?
Yes. The 4th has been made a pro forma respondent.
Yeah, all the 4 had appeared before the single bench.
Yes.
Yeah, who's for the respondents?
Be appearing on behalf of the state respondents, my lord.
Anything to submit?
Not let notice be issued. This is the first time it's coming up, my lord.
Petitioner number 1 was also seen with their mobile phone seat and clearly here.
We'll admit this appeal.
I'm obliged.
And matter be heard as early as possible.
Yes.
But meanwhile, insofar as the appellant's posts are concerned, don't go for fresh advertisement.
Yes.
Because they're already terminated. So no effective orders for stay of the termination order that has already taken effect.
Yes.
Heard Mr. Malhotra, then at counsel appearing for the appellant, learned additional AG appears on behalf of the respondents.
1 to 5 years.
1 to 5. This appeal is directed against the judgment and order dated 31/7/2026, passed by the learned single judge in WPC 123 of 2025. The writ petitioners had is it available here?
Yes. At page 66. The English
advertisement dated 17th February 2025 for the post of sericulture demonstrator. Is the post? Sericulture demonstrator.
Demonstrator.
Stop. The advertisement was published by the Directorate of Sericulture, Government of Mizoram, by the advertisement number 1 of 2024/2025 dated 17th February 2025. Stop. As per the advertisement, the
examination was conducted, Your Honor.
Selection process was conducted by way of a written examination. Stop. The examination was conducted by the Mizoram Public Service.
No, Your Honor, by the directorate itself.
By the directorate. Stop. In the said examination which was conducted, the writ petitioners appeared and successfully completed the examination. Stop. However,
Interview was conducted, Your Worship, subsequently.
followed by an interview, and pursuant to which the writ petitioners were appointed
Yes.
in the said post by which order?
Page 85.
85. Ninth of May 2025, issued by the Director, Agriculture Department. Stop. Pursuant to certain complaints made by some of the candidates that there was
Irregularities.
irregularities in the written examination conducted, including use of mobile phones, which is completely unauthorized. An inquiry was held
Page
by
91. Page 91.
by the
Committee.
by a committee which was set up
Page 91.
by the Secretary, Sericulture Department. Stop. By the said by a notification dated 14th of May 2025. Stop. The committee conducted the inquiry and submitted the report with the following recommendations, page number 108, Roman 6. Stop. Thereafter, an opinion of the law department was also obtained by the Sericulture Department. However, to the shock and surprise of the appellants, by the impugned order dated 29th of August 2025, the entire selection process for the recruitment to the 4 posts of sericulture demonstrator was cancelled, and a fresh recruitment process was sought to be undertaken. Stop. Further, the appointment orders which were issued to the petitioners dated 9th of May was also cancelled. Stop. Being agreed, the writ petitioners approached the High Court by filing WPC so-and-so. Well, upon hearing, the counsel for the parties, the learned single judge, by the impugned judgment and order dated so-and-so, dismissed the writ petition. Stop. The learned single judge declined to accept the submissions of the writ petitioners on the findings that some of the appellants were also, there were certain allegations against some of the appellants that they had also resorted to irregularities. Stop. Para. The learned counsel for the appellant submits that there is no specific allegation against the appellants that they had resorted to irregularities. Stop. That apart. The committee which was constituted did not recommend cancellation of the entire selection process. Rather, the recommendation of the committee was
Paper 1 and 2 maybe.
that paper 1 and 2 may be conducted afresh. And the officials were detailed in the examination hall for the earlier examination may not be deployed again. Stop. He further referred to the opinion rendered by the law department that there was no opinion that the entire selection process, including the appointment orders of the appellants, be cancelled. It is only if a systemic fraud is established that the entire selection process needs to be cancelled. Stop. The learned counsel for the appellant has referred to and relied on a judgment of a coordinate bench rendered in Sri Ranjit Kumar and others versus Union of India, reported in 2026 SCC Online GAU 4627. Stop. Referring to the said judgment, the learned senior counsel submits that the view of the division coordinate bench is that merely because allegations are raised of irregularities being resorted to by some of the candidates in the recruitment process, the entire process need not be cancelled. Where the illegalities committed by the candidates could be segregated from the others, then the entire process need not be cancelled. Stop. The learned counsel therefore submits that in the facts of the present case also, the allegations were in respect of some other candidates, and therefore there was no need to cancel the entire examination, and particularly after the petitioners, after the appellants were admitted and had worked for some months. So, under such circumstances, it is submitted that the appeal be admitted. Upon hearing the matter, the impugned judgment and order be set aside, and including the impugned order of cancellation of the appointment orders of the appellant, and they be reinstated in their services. Para. The learned additional AG submits that he would address the court on receipt of instructions if required in the matter on the next date. The learned counsel for the appellant further submits that during the pendency of the appeal, the operation of the impugned judgment and order be stayed, and the petitioners be permitted to resume their services. Stop. Para, having heard counsel for the parties, upon perusal of the pleadings before the court, this court considers it appropriate to admit the appeal. Accordingly, admit, call for the records. The matter be listed after 2 weeks. 3 weeks.
3 weeks, ma'am.
3 weeks. All right, 3 weeks. And meanwhile, how many posts? Four. Four posts in which the appellants were working as sericulture demonstrator under the Department of Sericulture shall not be filled up or processed for fresh recruitment without leave of the court. Matter be listed again after the returnable date.
Yeah, notice upon pro forma respondent, is it required? He was one of the petitions.
It's for you to decide. You're not claiming anything against it. Notice at this stage in respect of pro forma respondent is not issued.
I'm okay.
Item 7. Item number 8.
Yes.
May I please, Your Lordships?
Yes.
Your Lordships, as per the last order dated 15/7/2026, Your Lordships, steps were supposed to be taken by the applicants
Yes.
towards service to the private respondents number 1 to 961 through newspaper publications. That was duly done, Your Lordships, and the affidavit of service of the notice also has been placed on record, Your Lordship.
Along with the copies of the newspaper.
Yes, Your Lordship. Your Lordship, the relevant page, the order would be at page 372, Your Lordship.
372.
Yes, Your Lordship. That's the last order, Your Lordship, whereby the appellants herein were directed to take steps through newspaper publication. 384 would be the relevant page, Your Lordship, because there are lots of parties here. 384, Your Lordship.
384. No, the order directing paper publication is available here.
Yes, Your Lordship.
Passed on 15/7.
7, yes, Your Lordship.
All right. And you have done
Your
the
Lordship.
publication.
Yes, Your Lordship.
Anyone-
Thereby, Your Lordship, the publication was carried out on consecutive 2 dates, Your Lordship,
All right.
as per the order itself,
All right.
on the 13th and 14th, Your Lordship,
All right.
of August.
Your Worship, I'll be appearing on behalf of some of the private respondents, Your Worship. I've received instructions.
You don't know which as on date.
As 900 plus, Your Worship. We'll be filing up power.
All right. You're Mr.
I'm Mr. P.R. Paske, Your Lordship.
Mr. P.R. Paske appears for the applicant. In deference, Mr. Malhotra appears for some of the respondents. Whereas in deference to the order dated 15/7/2026, passed by the division bench, the applicants have caused paper publication for service of notice on respondents.
Number 1 to 961, private respondents.
Number 1 to 961 in the IA number 75 of 2026. Stop. The paper publications in terms of the directions of the court was but where have you filed the affidavit?
The affidavit of service has been filed, Your Lordship. If my learned local counsel would like to discuss.
102.
The relevant portion, Lordship, there's so many respondents, and the relevant portion, the affidavit portion is starting from page 118.
No, I am unable to find out.
369.
369.
Yes.
369. Okay. The applicants have filed the affidavit on 17th of August 2026, enclosing the copies of the newspapers, within quotes, Fangliani and the Mizoram Post. Stop. The publications were made for 2 consecutive days in both the newspapers on 13/8/2026 and 14/8/2026. Stop. Copies of the newspaper publications showing the advertisement, showing the publication of the names of the respondents are also enclosed to the affidavit. In that view of the matter, the directions of this court have been undertaken by the IA for causing paper publication. Mr. Malhotra, in the meantime, submits that he appears for some of the respondents, and he will receive his power within a period of 2 weeks therefrom.
Representing the state government, that is respondent number 962 to 964.
MS, you are the government advocate?
Yes, Your Lordship.
They are performer respondents. Lordship.
Government advocate appears for 962 to 964.
4.
And who are arrayed as the pro forma respondents. In that view of the matter be relisted again after 4 weeks. The respondents are permitted to file their objections, if any, in the meantime. List after 4 weeks. You want a fixed date?
Yes, Your Lordship.
30th September.
Deeply obliged, Your Lordship.
Yes.
Item number 9.
So I'm appearing as amicus. We've received the paperwork. We listed for hearing.
You have
Item number 12.